Ladies and gentlemen, welcome back to the Shafi Law YouTube channel. My name is Cheyenne Shafi, and I'm an intimate partner violence lawyer based in Toronto, serving the proud and fine people of the province of Ontario. And today, we're going to be tackling a huge, thorny, and complex topic that is full of noise and confusion. So buckle up, put your thinking caps on, and let's talk about affidavits. As a criminal lawyer specializing in domestic assault cases, I hear the word affidavit a lot. In fact, about half the clients who call my law firm following an arrest for domestic assault hold out hope for one reason or another that their loved one is going to get an affidavit to help them. Don't worry, Mr. Shafi. She's going to get an affidavit to drop the charges, the client often confides. I'm not worried, is my usual reply, because I've been doing this for a very long time, and I'm going to get the job done with or without an affidavit. And besides, the complainant probably isn't going to follow through. I just happen to know that the vast majority of Ontarians who make and receive promises about the affidavit following a domestic assault charge have no idea what they are, what they're designed to do, or what risks they carry. So what gives? What exactly is an affidavit? And why does so much talk about them lead to little more than hot air? Most importantly, why should Ontarians facing domestic charges replace faith in the affidavit with trust in their lawyer? I want to talk about why affidavits attract so much attention in the domestic context in the first place. As I've mentioned many times, once police are called to the scene of a domestic dispute, there is a very real chance that somebody is going to leave in handcuffs, whether the parties want that or not. That's because of a little-known policy called mandatory charging. Mandatory charging was designed to correct for decades of police turning a blind eye to domestic abuse. The policy certainly has some defensible and laudable aspects, and its aim to reshape social attitudes about domestic violence is truly a good thing. But like any sweeping policy, in many ways mandatory charging has replaced old problems with a set of new ones. And this is especially true in cases where couples who love each other and want to stay the course are told by the police that they can't. This fallout of the mandatory charging policy might be forgiven if Ontario's court system were simple and efficient and easy to access. But couples wanting to reunite are crushed when they find that the legal system is actually slow, confusing, and often just as counterintuitive as the police investigation that preceded it. It's little wonder that Ontarians stuck in this position then go searching for a solution. Something, anything that might restore control over their families and their lives. Enter the domestic assault affidavit. An apparently simple and elegant tool held out all over Google and the internet that promises like a magic wand to make unwanted domestic assault charges simply go away. But are affidavits truly a one-stop solution for unwanted domestic charges? The answer is, it's complicated. Firstly, what is an affidavit? An affidavit is simply a statement. The person making the statement is called an affiant. In domestic cases, that's usually the victim or the complainant. What makes an affidavit so special is that it is sworn, meaning that it is given under oath to a person called a commissioner of oaths. This is what gives the affidavit its special weight, but it's also what causes the affidavit to attract its special risks. What is the purpose of an affidavit? In domestic assault cases, affidavits are usually used to permit a victim to expand upon, clarify, revise, or recant, in other words, take back, what was said to or observed by police. Most victims or complainants who seek to prepare an affidavit do so with the objective or the hope of helping to get the domestic assault charges dropped. The question naturally arises then, can an affidavit help to get domestic assault charges dropped? Because affidavits are sworn statements prepared directly by the most important witness in a domestic case, yes, they can and often do have a profound impact on the course of a domestic assault prosecution. But this depends on the contents of the affidavit. It also depends on the other evidence that exists in the case. Let's look at these two factors in greater detail, starting with the actual contents of the affidavit. An affidavit is just a vehicle. What goes inside that vehicle? The things that a witness is actually prepared to say under oath in a sworn statement is the most important factor in determining the impact that that affidavit is likely going to have on a particular case. Take, for example, the common line that a complainant did not realize that their husband or boyfriend or loved one was going to be charged, and that they didn't want them to be charged, and that now that they have been charged, they would like to get those charges dropped. Statements like these are essentially useless in affidavit form. They merely express the complainant's intentions or wishes. An affidavit has next to nothing to do with the complainant's intentions and everything to do with new evidence. In the context of a domestic violence case, that means explaining what happened in the relationship, during the conflict, and after police arrive. By the way, have I mentioned how grateful my law firm would be if you hit the like button and the subscribe button? Subscribing to our law firm's channel will help us to commit more time, energy, and resources to preparing materials like these. Back to our content. What about the other evidence in the case? In the domestic assault context, affidavits are just one, albeit one powerful, item of evidence among many others that have already been collected by police. Consider, for example, the previous statements given to the police, sometimes under oath, the photos of injuries that were taken, if any, the body-worn camera footage of the police officers on scene, the notes of the police officers at the scene, including their observations of any utterances that were made by either the accused person or the complainant, any third-party witnesses who may have been present and who spoke to the police, any domestic violence risk management questionnaires that may have been completed by the complainant, audio of the 911 call, and so on and so forth. So quite apart from the actual contents of the affidavit, an affidavit's effectiveness, as you can see, depends a lot on what these other items of evidence are and how strongly or not strongly they support the prosecution's case. In fact, one of the main responsibilities of a criminal lawyer helping a complainant to prepare an affidavit is to protect the clients against making palpably false statements. This is done not only to help maintain the integrity of the process, but more importantly, to actually protect the client, which takes us to our next point. What are the risks associated with preparing a domestic assault affidavit? Complainants seeking to prepare an affidavit should be aware of the potential and often very serious legal risks associated with them. It is often a discussion of these legal risks that causes complainants to shy away from their preparation. For example, a false affidavit, that is, an affidavit which can be shown to contain a lie, can result in criminal charges for perjury. Although rarely charged, perjury is an extremely serious criminal offense and can carry very grave penalties. Even if an affidavit does not contain a lie, but is instead designed to correct a previous one, the contents can still expose the affiant to legal risks. For example, recantations. These often amount to little more than an acknowledgement that what the victim originally said to the police was false or designed to mislead them. The very act of making this admission, however commendable it may be if it's actually designed to correct an error, can result in a criminal charge for public mischief. If the original statement to police was itself under oath, which happens very frequently these days, Recanting that statement can also be the basis for a charge of perjury. Why do affidavits cost so much? Domestic affidavits range significantly, both in terms of cost and quality. In my experience, clients tend to get what they pay for. A poorly drafted affidavit is one that contains simplistic or even patently unbelievable statements. These types of affidavits are often prepared without consideration for the other evidence gathered by police, and can therefore contradict evidence that is staring the prosecutor in the face. Sloppy affidavits like these often fail to achieve the very outcome that a client has agreed to tolerate risk for. On the other hand, a high-quality affidavit is the result of extensive engagement with the client and the case. This means providing the client with a careful assessment of the proposed statement within the broader context of the evidence, as well as assessing the client's legal exposure and sometimes even having a frank discussion about the client's motivations. Affidavits prepared in this manner take considerably more time and therefore cost a lot more than a simple, quote, "it didn't happen." The end result, however, is a sworn statement which not only minimizes or even immunizes the client from legal risk, but is also far more believable and thus much more likely to obtain the desired result. How about affidavits of non-prosecution? Let me be perfectly clear about this. As of October 2023, affidavits of non-prosecution have no existence in Ontario domestic violence law. If we think back to our original discussion about the profound emotional challenges that come from domestic assault charges, I can understand the appeal. For the average Canadian, affidavit of non-prosecution just sounds simple, effective, and technical enough to be a real thing. But it's not. There is only one kind of affidavit in domestic assault cases in Ontario. These are statements given under oath designed to provide new evidence. This video may sound a lot like a warning cry against affidavits. And given the power affidavits can have in getting domestic charges dropped, a lot of my current and future clients might be forgiven if they're left asking, "Mr. Shaffey, what gives? Why are you railing against the instrument that can help our case?" The truth is, affidavits can be an extremely powerful tool for getting charges dropped. But whether you're facing domestic charges or you're a complainant thinking of preparing an affidavit, I hope this video has helped you to understand that they are not a miracle cure. Like everything else in the law of domestic assault, affidavits are complex instruments. Their quality, their effectiveness, their costs, the degree to which they expose the client to risks, all of these vary greatly. If you're facing domestic charges, recognize that the preparation of an affidavit is not in your control. Only your intimate partner can decide whether to prepare an affidavit and, just as importantly, what to say in it. Ladies and gentlemen, that's it for today's topic. I hope it was helpful for you. As always, please hit the like button and the subscribe button if you want to see more content like this. It takes an enormous amount of time and energy to craft reliable legal materials for consumption by the Canadian public. And I hope, as always, that you found this informative. If you have a domestic violence case or any other criminal case in the province of Ontario, please do not hesitate to call my domestic violence criminal law firm. My name is Cheyenne Chaffee, and it's been a pleasure speaking with you. I'll see you on the next one. Bye-bye.